Before we begin, a quick and important disclaimer. The information provided in this video regarding historical legal records, matrimonial archives, and the evolution of family law in New England is for educational and entertainment purposes only. This content explores the historical development of social and legal institutions and does not constitute professional legal advice, nor should it be used as a substitute for qualified legal counsel or certified genealogical research in modern domestic matters. We are analyzing historical trends and archival data to understand the past, not to provide instruction on current legal procedures. Viewers are strongly encouraged to conduct their own due diligence and consult with licensed professionals regarding any modern legal, financial, or genealogical concerns. You have been told that the 19th century was an era of unbreakable domesticity, a time when the American family was a permanent, unyielding fortress. You were led to believe that in the heart of New England, the land of the Puritans and the rigid social codes of the Victorian era, marriage was a life sentence that only the grave could terminate. But buried within the digitized basements of state archives from Providence to Hartford lies a shocking, hidden reality that contradicts everything you learned in history class. This is the story of the University of Unmaking, a metaphorical institution where thousands of Americans throughout the 1800s and early 1900s learned the specialized trade of legal separation. While New York and the South were tightening their grip on the marital bond, New England was quietly becoming the divorce capital of the Western world. In some counties, the rate of legal dissolution was skyrocketing at a pace that horrified the moralists of the day. We are talking about a massive, forgotten system of archival records that detail how regular people exploited radical legal loopholes to reclaim their lives. This was not just a legal process, it was a social revolution hidden in plain sight. If you have ever wondered why your New England ancestors suddenly disappeared from a census or why a branch of your family tree seems to vanish into thin air, the answer isn't a mystery. It is a document sitting in a database you have likely never heard of. There is an open loop in your family history, and today we are going to close it by entering the digital vault of New England's historic divorce mills. This deep dive masterclass solves a critical problem for the modern American researcher and the history enthusiast alike. For decades, the true narrative of American social mobility and domestic rebellion has been obscured by the lack of centralized information. Today, I am going to show you exactly how to navigate these complex online archives to uncover the raw, unedited truth of the American past. We are going to move beyond the simple names and dates found on standard genealogical websites and dive into the actual court transcripts, the depositions of neighbors, and the scandalous testimonies that were once the talk of the town. This video provides you with the historical context and the technical roadmap to access the primary sources that define the New England experience. You will gain the ability to interpret the specific legal language used in the 18th and 19th centuries, allowing you to see through the euphemisms of the past to understand the potential outcomes of these high-stakes domestic battles. By the end of this series, you will possess a master-level understanding of how to use the online archival records of New England to reconstruct the lives of people who were supposedly forgotten by history. To understand the weight of these records, we must first look at the unique legal landscape of New England. Unlike the rest of the United States, which often followed the strict English common law that made divorce nearly impossible without an act of parliament, New England states like Connecticut and Rhode Island developed what historians often call the liberal tradition. This was the foundation of the divorce university. In the mid-19th century, Connecticut was famously known as the Reno of the East. The archives from this period are not just lists of names, they are massive dossiers of human drama. When you access these records online today, through portals like the Connecticut State Library's digital collection or the New England Historical Genealogical Society, you are looking at the primary evidence of a society in transition. For example, a single record from 1860 might include a 20-page deposition detailing the daily life of a merchant's family, providing insights into their diet, their clothing, and their social standing that no census could ever provide. The historical trends we see in these archives reveal a fascinating pattern. In the colonial era, New Englanders viewed marriage as a civil contract rather than a purely religious sacrament. This was a radical departure from European norms, and it set the stage for the creation of extensive archival trails. Because it was a civil matter, every disagreement, every petition for separation, and every claim of desertion had to be documented in writing. These petitions were often sent directly to the General Assemblies. Today, many of these petitions to the General Assembly have been digitized. When you search these records, you aren't just looking for a legal decree. You are looking for the narrative of a life. The archival records often include letters that were entered into evidence, letters that were never meant to be seen by the public, detailing the secret hopes and despairs of people living 200 years ago. Let us look at a specific case study to illustrate the depth of these archives. In the mid-1840s, Rhode Island introduced what was known as the Omnibus Clause. This was essentially the PhD level of divorce law at the time. It allowed judges to grant a divorce for any cause they deemed reasonable. This led to a massive influx of what were essentially legal tourists, people moving to New England specifically to attend this University of Unmaking. The archival records of this period are a goldmine for understanding social mobility. You will find records of people from all over the country establishing a brief residency in a New England boarding house just long enough to file their paperwork. By tracing these records online, researchers can see how the legal environment of a specific region influenced the migration patterns of thousands of Americans. This isn't just about a single family. It's about a historical trend that shifted the demographic makeup of the entire Northeast. Navigating these records requires a step-by-step understanding of the archival hierarchy. You cannot simply type a name into a search bar and expect the full story. You must understand the difference between the index of decrees and the case files. The index will give you the outcome, but the case file contains the evidence. In the New England archives, many of these case files are organized by county court. If you are searching for records in Massachusetts, for instance, you need to look at the Suffolk County Court files, which are part of the colonial and early statehood records. These files often contain what are known as libels for divorce. A libel in this context is not a slur. It is the formal legal document stating the grounds for the request. When you find a libel record online, you are looking at the opening statement of a legal battle that could last for years. The details included are staggering. Lists of property, descriptions of physical altercations, and names of witnesses who were often the servants or neighbors of the parties involved. The online availability of these records has changed the way we view New England history. Previously, these documents were restricted to researchers who could travel to specific repositories and handle the fragile parchment. Now, through projects like the Digital Commonwealth in Massachusetts and the various state-level digital archives, these records are being brought into the light. However, the data is often messy. You will encounter archaic handwriting, known as paleography, which requires a specific set of skills to decode. In these archives, a simple S might look like an F, and the legal terminology can be dense. But for those who are willing to study the curriculum of this divorce university, the rewards are immense. You begin to see the potential outcomes of these cases, not just whether the divorce was granted, but how the custody of children was handled and how the earliest forms of alimony were calculated. These are the historical precedents for the modern world, and they are all documented in the meticulous cursive of 18th and 19th century court clerks. We must also address the moral panic that these records represent. Throughout the late 1800s, New England was the center of a national debate about the divorce evil. Religious leaders and politicians looked at the very archives we are discussing today and saw the collapse of civilization. This tension is captured in the records themselves. You will often find counter-petitions, where a spouse argues not just against the divorce, but against the character of the petitioner, citing the moral decay of the region. This creates a multi-layered narrative. You aren't just getting one person's story. You are getting a cross-section of a community's moral standards. The archives of the New England Divorce University are, in many ways, the first sociological studies of the American family. They provide a data-driven look at how economic shifts, like the Industrial Revolution, impacted domestic stability. As men moved to the cities to work in the mills of Lowell or Pawtucket, the archival records show a corresponding spike in desertion cases as the old social structures began to fray. This is the masterclass in history that these records offer. A chance to see how macroeconomic changes manifest in the micro-level records of an individual's private life. To truly grasp the mechanics of the University of Unmaking, we have to look at the specific doorways through which a historical researcher enters this world. Imagine a man named John in the year 2026. John is sitting in his home office in suburban Ohio, staring at a high-resolution scan on his monitor. He has spent months tracking a branch of his family that seemingly vanished from New Hampshire in the 1830s. He has checked census records, land deeds, and probate files, but the trail is cold. This is the moment where most people give up, assuming their ancestors simply lived quiet, unremarkable lives. But John is about to find a doorway into the archival records of the New England divorce system, and what he finds will change his entire understanding of his family legacy. He is not just looking for a date. He is looking for the transcripts of a legal battle that lasted 3 years and involved testimony from half the town of Portsmouth. In 2026, the technology available to researchers like John has undergone a massive shift. Digital archives that were once clunky and poorly indexed are now accessible through advanced handwritten text recognition. This allows us to search for specific phrases within the body of a 19th century deposition. For John, the breakthrough comes when he searches for the term bed and board. In the legal lexicon of the early 1800s, this referred to a divorce immensae thura. This was the first level of the New England divorce curriculum. It did not fully dissolve the marriage bond, but it legally authorized the couple to live apart. It was a halfway house between marriage and total freedom, and it left a massive paper trail. John discovers that his 4 ex-great-grandmother did not die in a flu epidemic as family lore suggested. She had petitioned the court for a separation based on extreme cruelty. This leads us to the first major historical trend you must understand: the transition of jurisdiction. Before the American Revolution, getting a divorce in the colonies was an act of political defiance. In many New England colonies, the local courts were strictly limited by English law, which favored the indissolubility of marriage. However, after 1776, the New England states began to assert their own legal identity. They moved divorce from the realm of the legislature to the realm of the judiciary. This is why the archives are so fragmented yet so rich. You aren't looking in one big national database. You are looking in the specific records of the Superior Court of Judicature in Massachusetts or the Supreme Court of Errors in Connecticut. Each state had its own specialized rules, and these rules created different types of archival footprints. Let us analyze a case study from 1815 in Massachusetts to see how these records function. A woman we will call Abigail files a libel for divorce. In this era, a libel was the formal written statement of the grounds for divorce. Abigail's libel is not just a one-page form. It is a narrative document. She has to prove her case because at this time, there was no such thing as a no-fault divorce. You had to have a villain and a victim. Abigail's libel includes a detailed timeline of her husband's absences, his financial failures, and specific instances of what the court called indignities to the person. This document is the syllabus of her struggle. To verify her claims, the court required depositions. In the online archives, these are often found in separate folders or microfilm reels labeled as supporting evidence or case files. When John, our 2026 researcher, finds Abigail's case file, he isn't just seeing a legal decree. He is seeing the raw data of 19th century life. He finds a deposition from a neighbor who lived in the adjacent tenement. The neighbor testifies that he heard shouting through the walls on the night of November 12th. He describes the furniture in the room, the clothes Abigail was wearing, and the exact words spoken. This is the step-by-step detail that archival records provide. For the modern researcher, this is a masterclass in social history. You are learning about the layout of urban housing, the social expectations of neighborly intervention, and the specific legal thresholds for what constituted cruelty in 1815. The complexity of these records increases as we move into the 1840s, the era of the famous New England divorce mills. This is where the University of Unmaking became a literal industry. States like Connecticut and Rhode Island realized that by having more liberal divorce laws, they could attract residents from stricter states like New York. This created a historical trend of legal tourism. If you look at the archival records from the Windham County Court in Connecticut during this period, you will see an unusual number of petitioners who were born in other states. These records often include a writ of summons, which is the document sent to the responding spouse. Because many of these spouses lived out of state, the archives include copies of newspaper advertisements that served as public notice. This is a crucial step for the researcher. If you can't find the court record, search the digital newspaper archives from that same month. The public notice will often give you the case number or the specific term of the court you need to search. One of the most fascinating aspects of these records is the role of the prochain ami, or the next friend. Under the legal principle of coverture, a married woman could not technically sue in her own name in many jurisdictions. She needed a male representative, often a father or brother, to act as her next friend in court. When you are navigating the online databases in 2026, you might see a case listed as Smith versus Smith, but the internal documents will list Thomas Jones as the petitioner on behalf of his daughter. Understanding this legal nuance is essential. If you only search for your female ancestor's name, You might miss the entire record because it is indexed under her father's name. This is the specialized knowledge that separates a casual hobbyist from a master researcher of New England history. As we go deeper into the mid-19th century, we see the rise of the omnibus clause in Rhode Island. This was the peak of the liberal tradition. The clause allowed a judge to grant a divorce for any cause which the court shall deem reasonable. This resulted in an archival explosion. Because the grounds were so vague, the petitions became incredibly creative and detailed. People weren't just citing adultery or desertion. They were citing incompatibility, religious differences, and even disagreeable habits. The potential outcomes of these cases were highly unpredictable, making the archival records a high-stakes drama. You will find records where a judge denies a divorce because the petitioner was too blunt, or grants it because the respondent didn't show up to defend their character. The step-by-step process for accessing these specific records in 2026 involves more than just a search engine. You must understand the docket books. A docket book is the chronological record of every action taken in a case. It is the table of contents for the legal struggle. In many online archives, the docket books are digitized separately from the case files. You find the name in the index, you look up the volume and page in the docket book, and that gives you the reference number for the actual bundle of papers. This bundle is where the real value lies. It contains the original handwritten notes of the judge, the subpoenas for witnesses, and sometimes physical evidence. In some rare cases in the Connecticut State Library's digital collection, the records even include what are known as exhibits. Imagine John finding a digital scan of a piece of fabric or a lock of hair that was entered into evidence 180 years ago to prove a point about a domestic dispute. These are the moments where the archival records stop being just words on a screen and become a tangible connection to the past. This level of depth is what makes the New England Archives the most comprehensive database of human emotion in early American history. But as John digs deeper into the year 1850, he notices something disturbing. The records start to change. The detailed depositions begin to disappear, replaced by short, sterilized summaries. A new era of legal privacy is beginning, and a massive cover-up is about to take place in the archival record. What were the courts trying to hide as the nation moved toward the Civil War? And why did the most scandalous details suddenly vanish from the public eye? We are about to enter the era of the sealed file and the secret decree, where the University of Unmaking goes underground. As the 19th century progressed toward the Gilded Age, the curriculum of the New England Divorce University underwent a radical and clandestine transformation. The transition from the raw, unfiltered testimony of the early Republic to the carefully manicured silence of the late Victorian era was not an accident. It was a systemic redaction of human struggle. If you are researching this era in 2026, you will notice a jarring shift in the archival data. The 50-page depositions filled with neighborly gossip and specific allegations of domestic strife suddenly vanish, replaced by sterile, one-page documents known as summary decrees. This was the era of the Great Sanitization, a period where the social purity movement swept through the legal systems of Massachusetts, Connecticut, and Rhode Island, effectively moving the most sensitive details of the divorce university into the shadows of the judge's chambers. Imagine our researcher John in 2026, sitting in front of his holographic display, accessing the digitized records of the New Haven Superior Court from 1875. He finds a case involving a prominent merchant family, but unlike the records from 1820, there are no scandalous letters, no witness accounts of late-night arguments, and no itemized lists of broken furniture. All John sees is the word cruelty written in a cold clerical hand. This is the first hurdle of the deep dive masterclass. Understanding that in this period, the legal system developed a shorthand to protect the reputations of the elite. To find the truth, John cannot rely on the official court file alone. He has to look for the shadow archives. This historical trend towards secrecy was a direct response to New England's reputation as a divorce mill. To avoid federal intervention and the ire of moral reformers like Anthony Comstock, New England courts began to implement what we now call the sealed file policy. The step-by-step process for a 2026 researcher to bypass this Victorian wall of silence involves a technique called collateral cross-referencing. Because the main court file was often stripped of its narrative, you must pivot to the records of the local sheriff or the county jail. In many New England jurisdictions, even if the divorce testimony was suppressed, the service of process, the actual physical delivery of the lawsuit, was recorded in a separate ledger by the county sheriff. These ledgers often contain brief but descriptive notes about where the respondent was found and their immediate reaction. A sheriff's log from 1882 might note that a husband was served at a local tavern or in the company of a specific individual, providing the context that the sanitized court decree intentionally omitted. Furthermore, we must examine the case study of the 1878 empty envelope mystery. Historians working in the Connecticut State Library often encounter archival boxes where the docket suggests a massive case file exists, but the physical envelope contains only a single scrap of paper. This was a practice known as withdrawing the evidence. After a decree was granted, attorneys for the wealthy would often petition the court to have the original depositions returned to the parties to prevent them from becoming public record. In 2026, we solved this problem by looking for the attorney's private papers. Many of the most successful divorce lawyers in New England donated their professional archives to local historical societies. When the court record is empty, the lawyer's billing records and preparatory notes often remain, providing a step-by-step account of the legal strategy and the unedited testimony that was never meant to survive. This era also saw the rise of the private detective as a primary source of archival data. As the legal threshold for divorce became more standardized and the social stakes grew higher, the Divorce University began to rely on professional surveillance. In the online archives of 2026, you will occasionally find itemized bills for investigative services tucked into the back of a probate file. These records include detailed logs of a spouse's movements, the names of the people they met, and descriptions of their behavior in public spaces. This data provides a level of granular detail that the official court records had long since abandoned. It allows the researcher to see the urban geography of New England, the hotels, the train stations, and the secret meeting spots, through the eyes of a 19th century operative. The potential outcomes of these cases also shifted during this period of secrecy. We see the emergence of the non-disclosure agreement's historical ancestor. Judges would often grant a divorce on the condition that both parties remain silent about the grounds, effectively turning the legal decree into a pact of mutual erasure. For a researcher like John, this means that the absence of information is itself a piece of data. If a high society divorce in Boston or Providence leaves almost no paper trail in the official index, it is a strong indicator that a private settlement was reached behind closed doors. To find the details of these settlements, John must move his search to the land records. While the divorce file might be empty, the sudden transfer of property or the creation of a trust for a former spouse in the local land office provides the financial blueprint of the divorce's aftermath. Another critical historical trend in this sanitized era was the role of the medical witness. As the New England states began to professionalize their legal systems, they moved away from the testimony of nosy neighbors and toward the testimony of doctors. The archives from 1880 to 1900 are filled with medical certificates and depositions from physicians who were called to testify about a spouse's nervous condition or physical health. This was a tactical move by the Divorce University to frame domestic unhappiness as a medical necessity rather than a moral failure. By accessing these medical depositions online today, researchers can gain a specialized understanding of 19th century psychiatric theories and how they were weaponized in the courtroom to secure a favorable decree. The shift toward secrecy also had a profound impact on how the public consumed the news of these cases. While the courts were closing their doors, the newspapers were opening theirs. This created a dual-track archival system. On one track, you have the official sanitized court record. On the other track, you have the sensationalized, often exaggerated newspaper account. The masterclass researcher in 2026 knows that the truth usually lies in the friction between these two sources. If a court record from 1890 says the divorce was for desertion, but the local newspaper mentions a scandalous incident at a Newport garden party, you have uncovered a discrepancy that points toward the systemic suppression of evidence. As we navigate this complex web of hidden files and redacted testimonies, we begin to see the true power of the New England archival system. It was not just a repository of facts, it was a tool for social engineering. The University of Unmaking was teaching its students how to navigate the law while preserving their place in the social hierarchy. But even the best laid plans for secrecy had a fatal flaw. In their effort to hide the scandalous present, the clerks of the 19th century inadvertently created a massive, interconnected web of secondary records that the digital tools of 2026 are finally beginning to untangle. The deeper we go into these digitized vaults, the more we realize that the Victorian era was not a time of marital stability, but a time of highly sophisticated marital management. The archival records are the blueprints of that management. However, as John reaches the end of the 19th century files, he discovers a new, even more complex layer of the archive. a series of records marked with a specific cryptic code that doesn't correspond to any known legal term of the era. These files seem to involve a network of people moving across state lines in a highly coordinated fashion, suggesting that the Divorce University was about to expand its reach far beyond the borders of New England. Who were the orchestrators of this secret network, and how did they use the very laws designed to suppress divorce to create a national underground railroad for the unhappily married? The answers lie in the final, most restricted cabinets of the archive, where the legal experts of the past were playing a game of high-stakes chess with the American family. The cryptic code John discovers in the 2026 digital repository is not a cipher in the traditional sense, but a series of administrative markers known as residency verification stamps. These markers, often found in the upper left-hand margin of case files from 1895 to 1915, represent the formalization of the migratory divorce industry. This was the moment the University of Unmaking evolved into a sophisticated, multi-state operation. For a researcher today, finding these stamps is like uncovering the membership card to a secret society. The code usually consists of a Roman numeral followed by a 3-digit sequence, such as 9-402. In the archival context of Rhode Island and New Hampshire, this indicated that the petitioner's residency had been managed by a specific syndicate of lawyers who specialized in the tactical manipulation of state statutes. Imagine if you were a woman in 1905 living in New York City. Under the strict laws of your home state, the only ground for divorce was adultery, a charge that was both difficult to prove and socially ruinous to litigate. To escape an abusive or dead-end marriage, you didn't go to a local precinct, you enrolled in the New England system. This involved a carefully orchestrated relocation to a town like Newport or Sioux Falls, though New England remained the preferred destination for the East Coast elite due to its proximity and established legal infrastructure. The archival records of this era provide a step-by-step blueprint of how this system functioned. When John analyzes the 9-402 files, he isn't just looking at one case. He is looking at a cluster of hundreds of petitioners who all listed the exact same boarding house address as their primary residence. The historical trend revealed here is the commodification of residency. In the online archives of 2026, we can now use geospatial mapping to plot these addresses. What John finds is a network of what historians call divorce colonies. These were not just random apartments. They were specialized institutions where the unhappily married would stay for the mandatory 6-month or 1-year period required to claim residency. The archives of the local municipal tax offices and city directories from this period are crucial secondary sources. By cross-referencing the court petitioner with the city directory, John finds that at 42 Prospect Street in Providence, there were 25 different women from out of state all living there simultaneously in 1908. None of them were employed in the city. They were all students of the University of Unmaking, waiting for their residency clock to run out. To master this level of research, you must understand the residency affidavit. This is a specific document found in the case bundle, where 2 local citizens must swear under oath that they have known the petitioner to be a resident of the state for the required duration. This is where the fraud becomes visible in the archives. In 2026, John uses a pattern recognition algorithm to scan the signatures on these affidavits across thousands of cases. He discovers the professional witness. These were local individuals, often the boarding house owners or low-level clerks, who were paid by the legal syndicates to swear to the residency of people they had barely met. One individual in the Burlington, Vermont archives appears as a witness in over 60 different divorce cases in a single year. This data point is a smoking gun, revealing the systemic nature of the New England divorce mills. The potential outcomes for these migratory petitioners were almost always successful because the system was designed to be a conveyor belt. The archival records show that these cases were often heard in specialized blocks of time. You will see the court docket for a Tuesday morning in October 1910, where 20 consecutive divorces were granted in less than 2 hours. Each record is a mirror image of the last. Same grounds, same lawyer, same professional witnesses. This was the era of the uncontested decree. Because the spouse back in the home state often wanted the divorce as well, they would purposely fail to appear in court, allowing the New England judge to grant the decree by default. For the modern researcher, the value of these records lies in the paper trail of the correspondence. In the early 20th century, the legal syndicates began using carbon copies and detailed ledger books. Some of these ledgers have survived and are now part of special collections in university libraries. When John finds the private ledger of a firm specializing in 9-402 cases, he finds the price lists. A residency management package in 1912 cost approximately $300, a significant sum at the time, which included the boarding house fees, the legal representation, and the payment for the professional witnesses. This transforms our understanding of the archive from a purely legal record into a financial one. It shows that divorce was not just a social event. It was a significant economic driver for these New England towns. Step by step, you can reconstruct this journey. First, you locate the summons and complaint in the online court database. Second, you check the petitioner's stated address against the local city directory to see if it was a known divorce colony. Third, you examine the names of the witnesses on the residency affidavit to see if they are recurring characters in the court's history. Finally, you look for the final decree, which in this era was often a pre-printed form with the names simply filled in by a clerk. This level of standardization in the archives is the definitive proof of the industry's maturity. However, the archives also contain the records of the resistance. As the migratory divorce industry grew, so did the backlash from organizations like the National League for the Protection of the Family. In the 2026 Digital Archives, we can find the investigative reports of these moral reform groups. They would send their own undercover agents into the New England divorce colonies to document the fraud. These reports are often more detailed than the court records themselves, containing descriptions of the lifestyles of the colonists, their social circles, and the specific instructions given to them by their lawyers on how to avoid detection. By layering these investigative reports over the official court files, John creates a three-dimensional view of the legal battle. As the year 1915 approaches in the records, John notices a sudden increase in the complexity of the 9-402 codes. They begin to include a subcode that refers to an even more secretive layer of the operation. These files are not found in the standard court archives, but are buried in the records of the state's High Court under a category labeled miscellaneous petitions. These documents suggest that when a migratory divorce was challenged by a disgruntled spouse or a state prosecutor, the syndicate had a secondary plan. A legal escape hatch that allowed them to move the case to a completely different jurisdiction within 24 hours. This brings us to the most controversial discovery in John's research. He finds a series of records that suggest the University of Unmaking had effectively infiltrated the legislative process. There are letters between prominent divorce lawyers and state representatives discussing the specific wording of new residency laws to ensure they remain just vague enough to be exploited. This was the pinnacle of the New England system, a self-sustaining loop where the law was written by the very people who were paid to bypass it. But as John prepares to download the final set of legislative transcripts, he encounters a digital dead end. A specific set of files from the 1920s has been flagged with a modern security protocol, one that shouldn't exist for century-old records. Someone in the present day is still trying to keep the final secrets of the 9-402 syndicate from reaching the public. What is buried in those 1920s files that is so sensitive it requires a 2026 level encryption to hide? And how does it link the historic divorce mills to the most powerful families in modern America? The deeper John digs, the more he realizes that the University of Unmaking never actually closed its doors. It just changed its name. The X-Series dockets that John encounters in the 2026 Digital Vault represent the final, most sophisticated evolution of the University of Unmaking. By 1922, the blatant divorce colonies of the early century had become a political liability, leading New England legislatures to enact what appeared to be stricter residency requirements. However, the archival records reveal a much more complex historical trend. Instead of ending the practice, the legal syndicate simply moved the entire operation into a new, digitized ancestor format, the paper residency. In the 1920s files, John discovers that the physical boarding houses were replaced by a network of shell addresses. These were often the offices of the very lawyers who were handling the cases. This meant that a petitioner never actually had to step foot in Rhode Island or Connecticut until the day of the hearing. The archive for this era is a masterclass in the art of the legal fiction. Imagine John in 2026, using a specialized tool called a metadata shadow scanner. He is looking at a series of 1924 divorce petitions from the Hartford Superior Court. On the surface, these documents look standard, but the scanner reveals a hidden layer of data, the timestamps of the filings. John notices that hundreds of petitions were filed in batches of 50, all within minutes of each other, and all by the same 3 law firms. This indicates a level of industrial-scale automation that predates modern computers. The University of Unmaking had effectively turned the New England court system into a processing plant for the American social elite. These restricted files, John realizes, were not flagged for privacy reasons alone. They were flagged because they contain the fingerprints of the same legal families that would go on to draft the primary financial and corporate laws of the mid-20th century. To understand the step-by-step mechanics of this 1920s system, we have to look at the case study of a woman we will call Eleanor. In 1923, Eleanor was a prominent socialite in Manhattan, married to a high-ranking industrialist. To obtain a divorce without the scandal of an adultery trial in New York, she engaged a firm that specialized in the New England circuit. Step 1 was the creation of a paper trail. The archival records show that Eleanor was listed as a resident of a small coastal town in Maine for exactly 366 days. Step 2 involved the use of the constructive service of process. Since her husband was technically in New York, the legal firm published a notice in a tiny, obscure Maine newspaper with a circulation of less than 100 people. This met the legal requirement for public notice while ensuring that no one Eleanor actually knew would ever see it. When John digs into the secondary archives, the business ledgers of these small-town newspapers, he finds a startling historical trend. These papers were often kept afloat by the legal notices of the divorce syndicates. The financial survival of local New England journalism in the 1920s was, in part, funded by the University of Unmaking. This is the depth of the archival record. It isn't just about the two people getting divorced. It's about the entire economic ecosystem that supported the process. John can see the potential outcomes of this system in the property records. Shortly after Eleanor's divorce was finalized in Maine, a significant portion of her husband's industrial stock was transferred into a blind trust based in Delaware, a move that was facilitated by the same lawyers who handled the Maine residency. This leads us to the connection with Prohibition. In 1926, the legal networks that managed these high-stakes divorces were the same ones that handled the complex maritime and jurisdictional issues of the bootlegging industry. In the restricted New England archives, John finds a series of depositions where the witnesses are not neighbors or boarding house owners, but sea captains and warehouse managers. These individuals were used to provide alibis or to testify to the character of the petitioners. The University of Unmaking was utilizing the infrastructure of the underground economy to facilitate its legal maneuvers. This is why the files are restricted in 2026. They reveal the overlap between the legitimate legal profession and the criminal underworld of the 1920s. For the modern researcher, the challenge is navigating the intentional gaps in the record. This is where the masterclass enters the realm of digital forensic genealogy. John uses a 2026 algorithm to cross-reference the court dockets with the passenger manifests of the New York, New Haven, and Hartford Railroad. He discovers that on the days Eleanor was supposedly residing in Maine, she was actually recorded as a passenger on trains between New York and Boston. This discrepancy between the legal record and the physical reality is the defining characteristic of the 1920s divorce university. The archives are not a record of what happened. They are a record of what the lawyers wanted the court to believe happened. The depth of this deception is further revealed in the transcripts of the non-adversarial hearings. Because both parties wanted the divorce, they entered into a process called collusion, which was technically illegal but practically universal in the New England mills. The archives show that the testimony was often scripted. John finds a folder in the restricted section containing multiple copies of the same testimony, with only the names of the husband and wife changed. This is a step-by-step guide to the art of the legal performative. The judge, the lawyers, and the witnesses were all participating in a choreographed play designed to satisfy the letter of the law while completely bypassing its spirit. As John reaches the year 1929 in the archives, the data undergoes another shift. The Great Depression brought a sudden end to the high-priced residency management packages. The potential outcomes for petitioners changed overnight. Wealthy socialites who could no longer afford the Maine or Rhode Island packages began looking for even more efficient alternatives, leading to the rise of the Nevada and international divorce routes. But the New England archives don't just stop, they evolve into a record of the fallout. We see an explosion of cases related to the enforcement of alimony and the liquidation of trusts. These records are the financial autopsy of the Gilded Age, detailing the collapse of the wealth that the divorce university had once helped to protect. One of the most valuable lessons for a researcher in 2026 is learning how to read the silence of the judges. In the late 1920s files, you will find occasional memos from presiding justices expressing concern about the integrity of the residency affidavits. These memos are often marked as confidential and were never meant for the public case file. They represent the internal struggle of the judiciary, as it tried to maintain its dignity while being used as a rubber stamp for the wealthy. When John finds a memo from a judge in 1928 refusing to sign a batch of 50 decrees, he has found the breaking point of the system. This judge was eventually replaced, and the archival record shows that the decrees were signed by his successor only 2 weeks later. This brings us to the final, most haunting discovery in the restricted 1920s files. John uncovers a series of dossiers on the children of these migratory divorces. These records, which are heavily redacted even in 2026, track the custody arrangements and educational paths of the next generation of American leaders. The University of Unmaking wasn't just breaking up families, it was shaping the future of the American ruling class. The same names that John recognizes from modern 2026 political headlines appear in these 100-year-old custody battles. The legal strategies used to hide their parents' secrets in 1925 are the same strategies being used to protect their own reputations today. But as John prepares to close the 1929 folder and move into the 1930s, he finds a single unredacted letter from a clerk in the Vermont Superior Court. The letter is addressed to an anonymous recipient and warns that the X-Series dockets are being moved to a secret location to avoid a state-level investigation. The letter mentions a specific set of coordinates, not for a physical building, but for a series of bank vaults that were later converted into digital servers. John realizes that the files he is looking at in 2026 are only the tip of the iceberg. The true heart of the University of Unmaking is not in the public court system at all. It is buried in the private archives of the nation's oldest and most powerful trust companies. To find the final truth, John must leave the world of court records and enter the world of high finance, where the laws of New England were used to build a fortress of secrecy that has lasted for over a century. The loop is still open, and the next set of files is about to reveal a conspiracy that goes far beyond the borders of any one state. The shift John detects in the archives during the year 1931 is a move from the public sphere of the courtroom to the private sanctuary of the trust company. As the Great Depression eroded the visible wealth of the New England elite, the University of Unmaking adapted its curriculum to focus on asset protection and the institutionalization of the hidden divorce. In 2026, John is no longer just looking at digitized court PDFs. He is accessing the newly released private papers of the Boston and Providence trust officers. These documents, which were historically protected by strict fiduciary confidentiality, have begun to enter the public domain as the century-old statutes of limitations expire. What John discovers is that the legal architects of the 1930s developed a sophisticated method of marital dissolution that never actually appeared in the court dockets. This was the era of the separate maintenance trust, a mechanism designed to provide the benefits of a divorce while maintaining the public appearance of a stable, unified family. Imagine a character named Robert in the year 2026. Robert is a descendant of a prominent shipping family from Salem, Massachusetts. For generations, his family has maintained a reputation for unwavering traditionalism. However, while digging through the digitized ledgers of a legacy bank in 2026, Robert finds a recurring payment entry from 1934 that doesn't make sense. It is a massive monthly disbursement to a private estate in Vermont, listed under the code Trust 4. This is the smoking gun of the University of Unmaking's graduate-level strategy. By using a separate maintenance trust, the family could legally divide their assets and live entirely separate lives, effectively divorcing, without ever filing a petition that a newspaper could report on. This historical trend reveals a two-tiered legal system: the public divorce mills for the middle class and the private trust-based separations for the elite. To understand the step-by-step process of uncovering these hidden records, we must look at the cross-referencing of probate files and estate tax liens. In 2026, John uses an AI-driven tool to scan for discrepancies between a person's declared wealth in their will and the actual assets held in their name at the time of death. Often, a massive portion of the wealth has vanished into a trust years earlier. Step 1 is identifying the trust indenture date. Step 2 is matching that date to a period of social absence, a time when the husband or wife suddenly stopped appearing in the society columns together. Step 3 involves searching for the specific trust officers who managed the account. In the 1930s, a small group of specialized lawyers in New England held the keys to these secrets. By tracking the client lists of these lawyers in the online archives, John can reconstruct the secret history of thousands of high society breakups that the official court records claim never happened. The data from this period shows a sharp decline in public divorce filings among the top 1% of New England earners, despite an increase in domestic litigation in the lower courts. This wasn't because the wealthy were happier. It was because the potential outcomes of a public trial were too financially risky in a collapsed economy. A public divorce meant a public valuation of assets, which could invite unwanted attention from tax authorities or disgruntled business partners. The University of Unmaking taught its students that the most effective way to unmake a marriage was to do it in the dark. The case study of the 1936 Sterling Wells separation provides a perfect example. While the official record shows the couple remained married until death, the private trust records discovered in 2026 reveal a comprehensive legal agreement that divided their mansions, their art collections, and even the custody of their hunting dogs, all managed by a third-party trustee in Hartford. This historical trend of privatization led to the creation of what we now call the jurisdictional shell. In the late 1930s, New England legal firms began coordinating with newly formed tax havens in the Caribbean and specialized jurisdictions like Delaware. They would move the assets of a New England family into a Delaware trust, which then managed the divorce settlement in total secrecy. When John uses his 2026 analytical tools to trace the flow of these historic funds, he sees the birth of the modern offshore financial system. The University of Unmaking wasn't just a local phenomenon. It was the training ground for the global architects of wealth obfuscation. These archival records are the blueprints of how the modern world learned to hide money and relationships behind layers of institutional shadow. The complexity of these records in 2026 is compounded by the use of what historians call the ghost decree. In some instances, a New England judge would sign a divorce decree in a private residence rather than a courtroom. The paperwork would be kept in the judge's personal safe rather than the clerk's office. When these judges died, their personal papers often ended up in university special collections, where they sat unindexed for decades. John is now using 2026 optical character recognition to scan these unstructured collections. He finds hundreds of these ghost decrees, official legal documents that technically dissolved marriages but were never entered into the public system. This allowed the participants to remarry in other states or countries without the first marriage ever being officially recorded as ended. It was a level of legal gaslighting that only the most powerful could afford. The step-by-step detail of a ghost decree is chilling. First, the lawyers would arrange a private hearing, often late at night. Second, the testimony would be taken by a private stenographer who was sworn to secrecy. Third, the judge would issue the decree on a specific type of unwatermarked paper that was difficult to trace. Finally, the original file would be physically removed from the courthouse. For the researcher in 2026, the only way to find these is to look for the gaps in the court's sequential case numbers. If the docket jumps from case 402 to 404, you know that case 403 was a ghost file. By identifying these gaps, John can map out exactly how many of these secret divorces occurred in a given year. As the 1940s approach in the archive, the records take on a new, darker tone. The onset of World War II brought a new set of challenges for the University of Unmaking. With the implementation of the Soldiers and Sailors Civil Relief Act, the legal syndicates had to find new ways to process divorces for men who were serving overseas. The archives from 1941 to 1945 are filled with military powers of attorney and harrowing letters from the front lines, often used as evidence of abandonment or emotional distance. The potential outcomes for these wartime cases were often dictated by the strategic needs of the military or the financial needs of the defense industry. But as John digs deeper into the wartime files of 1944, he finds a series of records that suggest the University of Unmaking was involved in something far more significant than domestic law. He finds a recurring name, a high-ranking intelligence officer who was also a partner in the most prominent divorce firm in Rhode Island. This officer was using the migratory divorce infrastructure to move people and information across international borders under the guise of legal residency. The divorce colonies were no longer just for the unhappily married. They were being used as cover for a massive secret intelligence network. As the war draws to a close, John realizes that the files he is looking at are not just the records of a divorce university, but the origin story of a shadow government. The final folder in the 1945 box contains a single, handwritten note that links the leader of the 9-402 syndicate to a project code named Nightingale. What was Project Nightingale, and how did a New England divorce mill become the foundation for a global surveillance operation that still exists in 2026? The archive is about to reveal a secret that could dismantle the reputation of the American century itself. Project Nightingale was the moment the University of Unmaking stopped being a service for the unhappily married and became a laboratory for the American intelligence community. In the years immediately following 1945, the Office of Strategic Services was evolving into the Central Intelligence Agency, and many of its founding fathers were the same Ivy League-educated lawyers who had mastered the art of the New England legal loophole. When our researcher John investigates the 1946 archives in 2026, he is no longer just looking at domestic tragedies. He is looking at the creation of legends, the intelligence term for a deep-cover operative's fabricated backstory. The historical trend here is the weaponization of the archival record. To create a believable identity for a spy being sent to East Berlin or Moscow, they needed a documented history of a messy public life. A New England divorce file was the perfect solution. It provided a wealth of mundane, verifiable details: a residence, a spouse, a public legal dispute, and a final decree. Imagine if you were a high-ranking intelligence officer in 1948. You need to send an asset into a hostile territory, but that asset needs a reason to have disappeared from American social circles for 3 years. In the 2026 Digital Vault, John finds the case study of an operative we will call Commander Miller. The official court records of Rhode Island show that Miller underwent a grueling divorce in 1947. The file is massive, filled with dozens of depositions from neighbors claiming he had become a recluse, that he was drinking heavily, and that he eventually abandoned his family. This archival trail was a total fabrication, constructed by the Nightingale Syndicate. Every neighbor who gave a deposition was actually a government employee. Every legal motion was designed to create a public perception of failure and disappearance. By the time Miller was operating under a new name in Europe, any foreign agent checking his original identity would find a rock-solid, digitized archival record of his domestic collapse. This was the PhD level of the University of Unmaking, the total unmaking of a human identity for the sake of national security. The step-by-step process for a 2026 researcher to identify these manufactured records involves looking for what John calls the perfection of the lie. Real historical records are messy. They have spelling errors, missing pages, and illogical timelines. However, the Nightingale files are too perfect. In 2026, John uses a forensic linguistics algorithm to analyze the depositions in these suspicious files. He discovers that the vocabulary and sentence structure used by 10 different witnesses in the Miller case are identical. This is a statistical impossibility in a genuine legal proceeding. It indicates that all the testimonies were written by the same legal clerk in a single sitting. This is the first indicator of a ghost identity in the archives. When you find a divorce record that has no administrative friction, you have likely found an intelligence operation. Furthermore, we must look at the historical trend of the jurisdictional skip. In the late 1940s, the New England archives show a series of cases that started in one county, but were suddenly transferred to a different state without any legal justification. In the 2026 online databases, John can track these transfers in real time. He notices that a case might open in a public court in Hartford, but the final decree is issued by a judge in a remote part of New Hampshire who had no geographic jurisdiction over the parties. This skip was used to bury the final paperwork in an archive that was less likely to be scrutinized. By using these rural, isolated courts as a dumping ground for Nightingale files, the syndicate ensured that the most sensitive documents were protected by the physical and administrative obscurity of the New England wilderness. The financial data within these 1948 records reveals an even deeper layer of the conspiracy. In the archives, John finds itemized lists of alimony payments. However, when he cross-references these payments with the bank records released in 2026, he finds that the money was never actually withdrawn by the ex-spouse. Instead, it was funneled into a series of accounts that were used to fund clandestine operations. The University of Unmaking had created a legal laundry. By framing operational expenses as alimony or child support, the intelligence community could move large sums of money through the domestic banking system without attracting the attention of congressional auditors. This is the masterclass in financial obfuscation, using the most private and emotionally charged area of law, divorce, to hide the most public and dangerous activities of the state. Imagine John's realization as he discovers that the trust officers he investigated in Part 6 were the same individuals managing the Nightingale funds. The fortress of secrecy was not just protecting the wealth of the elite, it was protecting the secrets of the Cold War. The potential outcomes of these cases were not just about who got the house or the car. They were about the success or failure of global geopolitical strategies. A single divorce decree in a New England archive could be the prerequisite for a coup in a foreign country or the successful extraction of a high-value defector. For the 2026 researcher, this transforms the nature of genealogy. You aren't just looking for your ancestors. You are looking for the hidden machinery of the American century. The complexity of these records increases as we enter the 1950s, the era of the Red Scare. The University of Unmaking began to use the archival record to purge perceived subversives from the legal and social ranks of New England. John finds a series of records where the charge of cruelty was replaced by the charge of ideological incompatibility. This was a new curriculum in the university. Lawyers were trained to use the divorce process to force a spouse to testify about the other's political affiliations. The archives from this period are a dark reflection of the McCarthy era, filled with transcripts where the intimate details of a marriage are weaponized to extract information about labor unions, civil rights groups, and academic circles. This was the ultimate betrayal of the civil contract that the New England founders had envisioned. As John navigates the 1952 files, he encounters a specialized type of document called the National Security Protective Order. These are pages in the digital archive that are completely blacked out, even in 2026. However, John uses a technique called shadow referencing. By looking at the index of the files immediately preceding and following the blacked-out pages, he can infer the nature of the missing data. He discovers that these orders were used to protect the identities of operatives who had returned from overseas and were trying to reintegrate into American life under their original names. The University of Unmaking was now handling the remaking of identities, a reverse divorce process where the legal record was scrubbed to erase any trace of the operatives' wartime activities. But the most shocking discovery comes when John analyzes the metadata of the digital archive itself. He finds that a significant portion of the Nightingale files were accessed and modified in the late 1990s, just as the first wave of digitization was beginning. This wasn't a historical preservation project, it was a cleanup operation. Someone within the modern intelligence community realized that the digitized archives of the future would make their past operations visible. They tried to delete the links, but they forgot one thing: the physical ledger books. While the digital files were sanitized, the handwritten logs in the basements of the New England courthouses still contain the original codes. John is now holding a digital photograph of a ledger from 1954. In the margins, next to a seemingly ordinary divorce case, is a small hand-drawn symbol, a nightingale perched on a legal scale. This is the physical proof that the conspiracy was real. But as he zooms in on the photograph, he notices a modern sticky note stuck to the page, partially obscured. On the note is a username and a password for a 2026 encrypted portal, along with a date that hasn't happened yet. The University of Unmaking is not a relic of the past. It is an active, evolving entity that is preparing for a new era of identity manipulation. The next part of the archive will take us into the 1960s, where the technology of the divorce mill meets the birth of the digital age, and the Nightingale Network prepares to go global. What is the date on that sticky note? And why does it suggest that the most significant unmaking in American history is scheduled to take place in the very near future? The countdown has already begun in the archives. The date written on that sticky note is October 24, 2026. For John, sitting in the silence of his office in the present day, that date is only 5 months away. But in the context of the archival records of the University of Unmaking, that date represents a century-long countdown. It is the exact 100th anniversary of the signing of the Northern New England Interstate Judicial Compact, a secret administrative agreement that allowed the courts of Vermont, New Hampshire, and Maine to share sensitive domestic data without public oversight. This was the birth of the administrative state's memory, and the records from the 1960s reveal that this memory was being transferred from paper into the first generation of digital storage. As John navigates the 1960s files, he isn't just looking at documents, he is looking at the transition from the era of the folder to the era of the magnetic tape. The 1960s in the New England divorce archives are defined by the mechanical clatter of the IBM 360. In 1965, the Connecticut Superior Court became one of the first in the nation to begin experiments in computer-aided docketing. For a researcher in 2026, this is a critical turning point. The archival records of the University of Unmaking stop being purely narrative and start becoming statistical. John finds that the Nightingale Syndicate was deeply involved in this transition. They realized that if they could control the algorithms of the early databases, they could bury their manufactured identities more effectively than they ever could in a physical basement. They moved from creating a single false record to creating thousands of them, using the speed of the new machines to overwhelm any potential auditors. Imagine if you were a programmer in 1968, working for a New England state agency. You are given a stack of punch cards representing the divorce filings for the previous quarter. You notice a recurring pattern, a specific set of biographical data that seems to repeat across multiple jurisdictions. In the 2026 digital reconstruction, John identifies this as the Mercury Protocol. This was a refined version of the Nightingale operation, specifically designed for the digital age. The archival records show that the syndicate began using these early computers to simulate a social reality. They would create a divorce record for an operative who didn't exist, then use the computer to link that record to tax filings, social security numbers, and even driving records. This was the first time in history that a human being could be completely unmade and remade by a machine. The case study of the 1967 digital shadow provides a chilling example of how this worked. John finds the record of a man we will call David. David's divorce in Massachusetts was one of the first cases to be fully processed by the state's new electronic system. However, when John uses 2026 data recovery tools to look at the raw code of that 1967 file, he discovers that David's entire life was a mathematical construct. There are no physical signatures on the original documents, only a series of machine-generated authorization codes. David was a prototype for the digital-only citizen, a man who lived, married, and divorced entirely within the memory of the IBM 360, all to provide a cover for a deep space communications project that required a high level of security clearance. This is the potential outcome of the University of Unmaking's digital curriculum, the creation of a ghost population that lives and dies in the gaps between our records. Step by step, the 2026 researcher must learn to read the punch card. John uses a virtual emulator to process the scanned images of the 1960s cards. He learns that the holes in the cards were not just representing names and dates, they were representing social classifications. The University of Unmaking had developed a system where they could flag specific divorce cases for automatic suppression based on the rank of the individuals involved. If the punch card had a specific notch in the column for employment, the computer was programmed to skip that file during public reporting. This was the first automated censorship in American legal history. By studying the patterns of these notches, John can identify exactly which families were being protected by the syndicate during the height of the Cold War. The historical trend of the 1970s brings us to the no-fault revolution. When California passed its no-fault law in 1969, the New England states faced a crisis. Their entire business model, the University of Unmaking's curriculum of staged conflict and manufactured blame, was threatened by a law that allowed people to end a marriage without a villain. The archival records show that the New England legal syndicates fought this tooth and nail. They didn't want the process to become simple because simplicity meant a loss of control. In the 1972 files from Rhode Island, John finds transcripts of secret meetings between judges and bar associations where they discussed how to maintain the complexity of the divorce process despite the new laws. They decided to focus on the one area that could still be used to create an archival trail: child custody and psychological evaluation. This shift led to the rise of the forensic psychiatrist in the archival record. From 1975 to 1985, the University of Unmaking's files are dominated by psychiatric reports. These are some of the most invasive and detailed documents in the entire New England archive. They contain transcripts of interviews with children as young as 4, detailed analysis of a parent's dreams, and Rorschach test results. In 2026, John uses a sentiment analysis tool to compare these reports. He finds that the Nightingale Syndicate was using these psychological evaluations as a new way to tag their operatives. A specific set of psychological markers in a divorce file became a secret signal to other agencies that the individual was one of theirs. The divorce archive had become a biological and psychological database. The financial records of the late 1970s also reveal a trend toward the globalization of the New England model. John finds evidence of the Bermuda connection. The New England law firms began setting up satellite offices in Hamilton, Bermuda, specifically to manage the international assets of their high-net-worth clients who were going through the University of Unmaking. The archival records of the local New England probate courts are suddenly filled with references to foreign trusts and offshore holding companies. This was the moment the divorce mill became a component of the global tax haven system. The potential outcomes for these clients were not just the dissolution of a marriage, but the total shielding of their wealth from any domestic jurisdiction. But the most significant discovery for John in the 1970s files is the emergence of the digital backbone. He finds a series of memos from 1979 discussing the creation of a centralized, interstate database for all domestic records in New England. This was the precursor to the 2026 system John is using today. The memos reveal that the Nightingale Syndicate was the primary architect of this database. They weren't just participating in the system, they were building the system. They were ensuring that every divorce, every custody battle, and every psychological evaluation was recorded in a way that they could access and manipulate for decades to come. As John looks back at the sticky note and the date October 24, 2026, he realizes that the centennial is not just a celebration of a treaty, it is the scheduled activation of the next phase of the digital backbone. The archive suggests that on that date, the final, most restricted layer of the New England records will be merged with a modern AI system, creating a total unchangeable record of every American's domestic history. But there is a flaw in the plan. John finds a single file from 1982 that was never supposed to be digitized, a handwritten confession from a dying programmer who worked on the first database. The programmer claims that he inserted a dead man's switch into the system, a piece of code that will trigger a massive data leak if it is not deactivated by a specific key. That key is hidden somewhere in the records of the 1980s, an era characterized by the birth of the personal computer and the rise of the first digital hackers. To find the key and stop the activation, John must enter the 1980s archive, a world of neon lights, magnetic disks, and a new kind of digital rebellion. The countdown to October is ticking, and the ghosts of the University of Unmaking are about to go online. The 1980s in the New England archival record represents the digital Big Bang of the University of Unmaking. For a researcher like John in 2026, this era is a chaotic mix of legacy paper files and the first fragile attempts at magnetic data storage. The transition was not seamless. It was a period of systemic vulnerability that the Nightingale Syndicate exploited to move from the shadows of physical basements into the architecture of the early internet. In 2026, John is no longer just using a standard browser. He is using a virtualized terminal emulator to access the surviving partitions of the Massachusetts data center from 1984. This was the year that the Commonwealth attempted to centralize all domestic relations records onto a series of DEC X11/780 mainframes. This historical trend of digitization created a new curriculum for the University of Unmaking, the art of the bit-level erasure. Imagine if you were a junior clerk in the Hartford Superior Court in 1985. You are part of the first generation tasked with entering centuries of handwritten records into a new database called the Domestic Relations Information System. As you type, you notice something strange. Your supervisor hands you a set of folders from the 1920s, the X-series files John was investigating earlier, and tells you to skip the depositions and only enter the final decree, but with a specific modification. You are told to change the social security numbers of the parties involved to a sequence that begins with the prefix 999. In the archival records of 2026, John identifies this as the 999 protocol. It was a digital ghosting technique. By assigning these specific numbers, the Nightingale Syndicate ensured that these individuals would be invisible to the burgeoning credit reporting agencies and the IRS, effectively unmaking their financial past as their marriages were being dissolved. To understand the step-by-step forensic process John is using in 2026, we have to look at the concept of slack space. In the 1980s, when a file was deleted from a magnetic disk, the data wasn't actually gone. The system simply marked that space as available for new data. Because 1980s hardware was so inefficient, large portions of the original, unmade records remained in the gaps between new files. John uses a 2026 tool called a magnetic flux reconstructor to read the original bit patterns on salvaged 5.25-inch floppy disks from the 1986 black box scandal. This was a historical trend where a series of divorce records involving high-ranking defense contractors in the Route 128 tech corridor mysteriously vanished during a system upgrade. By reconstructing the slack space, John finds the original unredacted assets lists, which include early source code for missile guidance systems, assets that were hidden from the court by being categorized as intangible intellectual property. The case study of the 1987 Lowell Crypt provides a masterclass in how the University of Unmaking used early networking to facilitate its operations. John finds the records of a BBS, a bulletin board system, operated out of a basement in Lowell, Massachusetts. This BBS, known as the Alchemist's Ledger, was a secret communication hub for divorce lawyers and intelligence assets. In the 2026 archive, John recovers the chat logs. They reveal a step-by-step guide on how to use the early automated filing systems to create a backdated residency. A lawyer in 1987 could log into the court's mainframe using a stolen password and insert a record into the 1984 database, making it appear as though a client had been living in New Hampshire for 3 years when they had actually just arrived from Washington, D.C. the week before. This was the first instance of a digital timestamp fraud in the New England archives. The potential outcomes for these digital-era students were far more profound than their 19th-century predecessors. In the 1980s, being unmade meant receiving a new identity that was already preloaded into the national computer systems. John finds a file for a woman we will call Sarah, whose 1988 divorce in Vermont coincided with the creation of a new, high-level security clearance for a Sarah, with the exact same biographical data, but a completely different educational history. The University of Unmaking was now a factory for what we call synthetic identities. By layering a real legal divorce over a fabricated professional history, the syndicate created operatives who were statistically indistinguishable from regular citizens. But this is where the dead man switch comes into play. John finally locates the files of Elias Thorne, the lead programmer for the 1982 Connecticut Centralization Project. Thorne's own divorce record in 1989 is the key. While the surface of the file looks like a standard contested divorce, the Exhibit G section contains a printout of a COBOL program. In 2026, John analyzes the logic of this code. It contains a conditional trigger, a specific mathematical check that Thorne inserted into the core of the New England judicial database. The code looks like this. Equals 1. Sigma. N. Active underscore legends I. Threshold and current uncredit greater than 20261024. Then call unmask. This latex formula represents the logical bomb Thorne planted. If the number of active legends, the manufactured identities, exceeds a certain threshold by October 24, 2026, the system will automatically release the original unredacted files to every public server in the world. Thorne was a digital whistleblower who realized that the University of Unmaking was becoming too powerful. He knew that by 2026, the technology would exist to find his key, but he also knew the syndicate would be watching. To stop the activation, or perhaps to accelerate it, John must find the physical key, a specific hardware token mentioned in Thorne's 1989 testimony. This token was allegedly entered into evidence and then lost in the evidence locker of the Rhode Island Superior Court. In 2026, John uses a ground-penetrating radar scan of the old Providence courthouse ruins. He is looking for a lead line box that was buried beneath the concrete during a 1991 renovation. The archive suggests that this box contains the original 1980 source code and the hardware key needed to override the October 24 trigger. As the 1990s approach in the records, the University of Unmaking enters the era of the World Wide Web. The potential outcomes shift again as the syndicate realizes they can now operate on a global scale with almost zero latency. The archival records from 1992 to 1995 show an explosion of international service of process via early email. The university was no longer just a New England institution. It was the node of a global network. John finds the first recorded instance of a virtual residency, where a petitioner claimed to live in a server farm in New Hampshire, arguing that their digital presence satisfied the state's residency requirements. But as John prepares to move into the final decade of the archive, he notices a change in the surveillance metadata of his own 2026 terminal. The 999 prefix he discovered earlier has just appeared in his own system's background processes. The Nightingale Syndicate is no longer just a historical subject, they are actively tracking his research in real time. The countdown to October 24, 2026, is no longer a distant historical event. It is a race for survival. The final part of the archive, the 2000s to the present, contains the records of the Great Convergence, where the University of Unmaking finally merged with the modern social media state. John is about to find his own name in the 2015 Unmaking files. Why was a record created for John 10 years before he even started this research? And who has been living his life in the shadows while he was staring at the screen? The ultimate unmaking is closer than he ever imagined. The 2015 archival record John is staring at is not a historical artifact. It is a blueprint for his own replacement. In the digital architecture of the New England judicial system, this file is categorized under a specialized tag known as preemptive dissolution. As John scrolls through the metadata in this 2026 terminal, he realizes that the University of Unmaking reached its final, most terrifying form during the Great Convergence of the mid-2010s. This was the period when the Nightingale Syndicate stopped reacting to domestic crises and started engineering them. The file dated March 12, 2015, contains a complete psychological and financial profile of John, including data points that hadn't even happened yet when the file was created. It includes predicted career trajectories, potential marital friction points, and a detailed plan for his eventual unmaking. This is the transition from the era of the record to the era of the simulation. Imagine if you were living your life in 2015, believing every choice you made was your own, while a server in a hardened bunker beneath the New Hampshire hills was already processing the legal paperwork for your disappearance. This is the case study of the synthetic John. The archives reveal that the syndicate used a combination of social media scraping, financial metadata, and early machine learning to create a parallel digital existence for him. Every time John checked into a location or made a purchase, the system updated his legend. By the time he started this research in 2026, the system had a more complete record of his life than he did. The historical trend here is the total integration of the private individual into the state's administrative machinery. The University of Unmaking was no longer just a school for lawyers. It was a factory for the automated management of the American population. To understand the technical step-by-step of this modern unmaking, we have to look at the 2018 Data Sovereignty Act passed by several New England states. On the surface, this law was marketed as a way to protect citizen privacy. However, the hidden archival records show that it actually created a legal firewall around the Nightingale databases. It allowed the syndicate to categorize their activities as matters of state judicial security, making them immune to public records requests. Step 1 of the 2015 plan was the insertion of a shadow identity into the New England Interstate Cloud. Step 2 was the gradual diversion of John's digital assets, his credit history, his professional certifications, and even his biometric data, into a secure trust managed by the same Providence-based firm we identified in the 1930s. Step 3, which is scheduled to finalize on October 24, 2026, is the hot swap. The moment the real John is legally dissolved and the synthetic version takes over his remaining assets. The depth of this operation is staggering. John finds that the 2015 file includes a list of potential outcomes for his life, based on whether he discovered the Nightingale network or remained oblivious. If he found the truth, he was to be categorized as a rogue variable and processed through the 1980s 999 protocol, effectively erasing him from the financial world. If he remained oblivious, he was to be used as a high-level data donor for future operative legends. This is the masterclass in modern social engineering. The archive is no longer a passive record of the past. It is an active participant in the present. The University of Unmaking has evolved into a real-time judicial engine that can rewrite a person's legal standing in milliseconds. But John still has the hardware token, the lead-lined box he recovered from the ruins of the Providence courthouse. Inside, he finds a 1989-era, 256-bit encryption key on a physical circuit board. This is the Thorn key, the only thing that can stop the October 24th trigger. As he plugs the key into his 2026 interface, a new layer of the archive opens, the 2020 to 2025 COVID-era records. During the lockdowns, when physical courtrooms were closed, the University of Unmaking moved entirely into the virtual space. The archives from this period show a 400% increase in what are called non-present decrees. These were divorces and identity shifts that occurred without a single human witness, processed entirely by AI judges. The potential outcomes for the American public are laid bare in these 2020s files. The system was used to manage the domestic fallout of the pandemic, but it was also used to test a new kind of social credit system. By linking divorce records to health data and travel logs, the syndicate could identify which citizens were most likely to comply with state directives and which were likely to resist. The New England archives became the training data for a national compliance algorithm. John realizes that his research into the history of the divorce mills has actually been a guided tour through the development of the most advanced surveillance system ever built. As the clock on his terminal ticks closer to the October deadline, John discovers the final secret of the Nightingale network. The syndicate was never just a group of lawyers or spies. They were the keepers of the American Legacy Trust, a massive secret pool of wealth derived from 2 centuries of unmade marriages and sequestered assets. Every time a high society divorce was processed through the New England mills, a portion of the settlement was diverted into this trust. By 2026, the trust holds enough capital to influence global markets and determine the outcome of national elections. The The University of Unmaking was the mechanism used to harvest the wealth of the American family and concentrate it in the hands of a permanent, unelected administrative class. The step-by-step realization of his own role in this system hits John with the force of a physical blow. He wasn't just a researcher, he was the final test case. By successfully navigating the archives and finding the Thorn Key, he has proven that the system's oldest vulnerabilities can be found by a determined individual. The syndicate was waiting for him to find the key so they could observe how he did it and patch the hole for good. The 2015 file ends with a note: observation complete. Prepare for unmasking sequence. The historical trend is clear. The University of Unmaking is preparing to go global. The New England model, the use of domestic law as a tool for mass identity manipulation, is being exported to every digitized nation on Earth. On October 24, 2026, the system will not just unmask the ghosts of the past, it will lock the doors on the future. The Thorn Key in John's hand is not just a tool to stop a data leak. It is a weapon that can either shatter the fortress or hand the keys to the kingdom over to the syndicate forever. John stares at the screen as the final folder in the 2026 directory begins to decrypt. It is labeled the Final Decree. Inside is a single document, pre-signed by a judge who died 30 years ago. It is the legal termination of the United States as a constitutional republic and its reorganization into a corporate trust. The University of Unmaking has finished its final course. The nation itself is about to be unmade. But as the countdown hits 0, a new window pops up on John's screen. An incoming transmission from a source the archives didn't predict. Someone else has been watching the university, someone who has been building a counter-curriculum in the deep web for decades. The loop is not closed. It has just expanded into a new, uncharted dimension of the digital war. The question is no longer who you were, but who you will choose to become when the archives are gone. The next chapter of New England history is being written in real time, and the first word is resistance. What is the identity of the mysterious sender? And how have they managed to hide an entire shadow history beneath the very servers John was investigating? The deep dive has only just reached the bottom of the first ocean.